We continue our argument session with case number 2022 P1068 Bonnie CHAN versus MARYLOU, SUDDERS, and others. This case is also partially impounded. I'll just remind counsel to refrain from reference to any of the impounded material that may not be open to the public.
May it please the Court, my name is Joel Rosen. I represent Annalisa Palomares and her mother, Bonnie CHAN. About 8 years ago, Attorney Marks and I negotiated a settlement on behalf of our clients which required that the HLD document include a medical necessity narrative. This was done as a sub-regulatory document. There were no hearings, no rulemaking, so we can't cite to public hearings that explain what the parties' intentions were the way we might otherwise do. But the reason we wanted it in there was to make the HLD coextensive with the EPSDT laws that require that any medically necessary service that a child requires is going to be provided, whether or not it's in the state plan. It's extremely broad. And we
What's extremely broad?
The EPSDT mandate is extremely broad and requires if a child has a medical necessity for a service, it will be provided, even if it's not in the state plan.
Don't you have to start with the need for a handicapping malocclusion?
Yes.
And doesn't this case turn on that question, whether or not there was a handicapping malocclusion?
Yes, a handicapping malocclusion is the same thing as medical necessity. If there is a handicapping malocclusion, treatment is medically necessary, and if treatment is medically necessary, there is a handicapping malocclusion. So in this case,
Okay, so your expert didn't even say that the child has a handicapping malocclusion. What do you say to that?
The experts agreed that the child had an impairment which, if not treated, would become worse. They used the word, I'm sorry, I'm freezing up. They used a word like handicapping malocclusion.
Use dental necessity.
Well, that was a whole other.
Okay, so I don't want to throw you off track. What language were you searching for if it wasn't handicapping malocclusion?
Traumatic occlusion was the term that they used. It just came to me. That was the term that both experts used.
But just to go back to what you said before, which I have to say I tend to agree with, and based on my understanding of the case, medical necessity in this particular instance is the equivalent or is identical to handicapping malocclusion. If there is a handicapping malocclusion, there's medical necessity. If there is no handicapping malocclusion, there is no medical necessity.
Correct. That's
and so while the experts used a different term, the term they did not use was the one that seems to be the term that is essential to the determination of medical necessity in this instance.
They used the term traumatic occlusion. I do believe.
Is there any evidence or other regulatory support for a conclusion that traumatic occlusion is identical in scope, range, and meaning to handicapping occlusion?
I think traumatic occlusion is a word that orthodontists use to indicate a handicapping malocclusion.
Why do you say that, and where is that evidence?
If that were the case, it would have been so much more helpful to have had the experts explain that to the hearing officer and the hearing panel, because it seems to me that if someone had supported that suggestion on the record, we wouldn't be having this conversation. But for you to, and I have no disrespect for your knowledge and expertise or study in this area. But your suggestion at that podium is not the same for these purposes as the expert explanation
Yes.
on the record.
That's correct. It'd take me a second to find it, but Dr. Riscala, who was representing the Annalise, submitted a flow chart, and I am I don't have it in front of me, but I'm pretty sure that the flow chart does say that treatment is medically necessary because there is a handicapping malocclusion. I would have to find it, but my memory
Who
is
says that?
that's
The
what
flow chart says that?
Pardon me?
Who says handicapping malocclusion? Because your opponents in their brief made a point of saying no one ever said handicapping malocclusion, including Dr. Riscala. So if you're going to tell us differently, I'd like page and verse, please.
If I could
Well,
just...
and I'd also, just out of courtesy, appreciate an explanation of why you didn't say that in the brief so that we could have anticipated. It's a pretty important point in the way that the laws tie together here.
I'm reading from the decision of the hearing officer, and I do not see the words handicapping malocclusion. It says that he said that it was medically necessary and it was reasonably calculated to prevent a condition that would result in infirmity and so forth. And he had checked off that the harmful condition of occlusal trauma would cause gum and bone infirmity, cause tooth infirmity, and cause emotional infirmity.
Are you saying that's...
So I don't see the words handicapping malocclusion.
Okay, so now we get back to where we were before you suggested that those words were in place. And so now, having established that the governing condition must be a handicapping malocclusion, we do not have a basis to describe this condition as a handicapping malocclusion, and yet your argument is that we should construe the statute and the regulations to allow for a medical necessity that is not a handicapping malocclusion, despite what I thought we had begun with as a recognition that under the statutory and regulatory scheme, a medical necessity exists when and only when there is a handicapping malocclusion.
Well, if what you're suggesting is that the inclusion of those words, handicapping malocclusion instead of traumatic malocclusion, which checks all the other boxes that says that
Doesn't say traumatic malocclusion. It says traumatic occlusion, I believe.
traumatic occlusion.
I believe. And, you know,
Well,
I think what that means is the
a
teeth are hitting each other so that enamel's coming off. That doesn't tell us that it's handicapping, which it seems to me is the operative and key word.
Can I offer just a separate gloss on that, which is, there's no question your client has a condition with her teeth. The ultimate question from 20,000 feet up is the condition severe enough that there should be public funding of it? Isn't that the essence of discretion, especially where here you're admitting there's no auto-qualifying condition, you're admitting it doesn't score on the second criterion, so you're relying on this catch-all category. And the hearing examiner said, in lay terms, not bad enough.
Well, the hearing officer was faced with First of all, a malocclusion is just a misalignment of teeth. The word malocclusion, we know that the teeth were misaligned. The experts agreed that they were misaligned. So there is a malocclusion, and it's traumatic. Now, whether you consider that handicapping, is it medically necessary? Is it a condition
Isn't that the essence of a judgment call? Whether or not this condition, which didn't meet the first two criteria, is bad enough to qualify for public funding?
I don't think so. I don't think you can make a judgment call when the experts, that is the Commonwealth's expert and the plaintiff's expert, both agree that there is a condition that is bad enough that they both agree that medical services should be covered.
While we're talking about expertise, we also need to acknowledge the role of the administrative agency here in promulgating and then interpreting and administering the regulations that they are charged with enforcing and administering. And whatever support there might be in your argument as a matter of text and interplay among the various provisions, it's also difficult for me, and again, I'll just confess my approach coming into this case. It's difficult for me to see how a judge in the Superior Court or we should conclude that this is an instance where there is no basis in the text or in law to support the administrative agency's interpretation of its own regulations.
The hearing officer at the Board of Hearings does not work for the administrative agency. The purpose of the fair hearing is to have an independent person. They are part of EEOC, yes, but it's to have an independent person to see whether the agency was right or wrong. In this case, and the hearing officer cannot make up facts, all right? Both experts agreed that there was a dental problem that would get worse if not treated. And in fact, she made that finding in her.
You know, here's, I think I'm at 20,000 feet with Judge Milkey. There have to be, and I don't know them all off the top of my head because I don't and never did practice in this area, but there have to be thousands of situations where someone would say, medically, it might be a good idea to do X. And yet, the regulations say it's not necessary, it's not medically, removal of a mole. I mean, I can just think of many, many of them, right? And isn't that what we're talking about here? In other words, yes, both the experts agree that if somebody wants to pay for it, it might be a good idea to have her teeth addressed. But the question is whether the state should pay for it because it's handicapping. Isn't that what we're talking about?
That's what we're talking about, and the state's expert, Dr. Kaplan, says this is a traumatic occlusion. It needs to be addressed. I'm willing. I think that we should.
Does he say it needs to be addressed? Because my understanding is when the actual standard was explained to him, he said, "Well, then no. I guess it's not medically necessary. It's what he called dental necessity. If I were a dentist, I'd recommend that she have it done. She's got a tooth that's chipping."
That is that conversation in the hearing is a very strange conversation. They're all set. They're all ready to approve it, right? And then Dr. Riscala asks Kaplan, but it's got to be medically necessary. And Kaplan says, well, no, it's not a medical problem. You can tell. You have to read the transcript. You can tell. He's not saying it's not medically necessary. He's saying it's a dental problem. It's not with the body. It is with the mouth. It's almost as if they're saying that the mouth is not part of the body. It is a.
So if he didn't understand the standard, I don't know that you can rely on his testimony as being conclusive on this point, right?
Well, he understands what's he understands
What
that
he would
this is
recommend as a dentist, and that's what he's saying.
He understands, well, right. Look, medically necessary means dentally necessary in this context because Medicaid only pays for medically necessary treatment, and dentistry is included in the category of medically necessary treatment. So under the EPSDT standards, he has to, if it's dentally necessary, it's medically necessary. I think that conversation confused the hearing officer, but if you read it yourself, and I'm sure you have, you can see that he thought treatment was medically necessary because he wanted to approve it until he got into a debate about whether it was medically or dentally necessary.
Until he started looking more closely at the regulations, I think.
Excuse me?
Until he started looking more closely at the regulations and what they specified.
I don't think anyone looked at the regulations. I think the two dentists got into a legal debate, which they were not qualified to do.
I think we'll have to leave it there. Thank you very much.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, David Marks, Assistant Attorney General for the Mass Health parties, defendants. Let's be
I trust
precise.
that you're fully recovered, Mr. Marks?
I'm sorry?
I trust that you're fully recovered?
I'm here. Yes, I have, and thank you for
I see that you're here,
accommodating me.
and, glad that you are fully recovered.
I appreciate it. So let's start with being precise about the terms used. No one said traumatic occlusion. The term used was occlusal trauma. That means during the bite, enamel was chipping off the teeth. That's the term Dr. Riscala used. That's the only term that was used to describe what was happening, occlusal trauma. Second of all, no one testified that what this patient had was a handicapping malocclusion, and the hearing officer found that there was no clinical information that might rise to the level of a severe and handicapping malocclusion. And the hearing officer, that's at page 48 of volume 2 of the record appendix, and the hearing officer concluded, page 51 of volume 2, that the medical necessity narrative that Dr. Riscala filled out does not clearly demonstrate why comprehensive orthodontic treatment is medically necessary to treat, quote, occlusal trauma and, quote, crowding, including to correct or significantly ameliorate a handicapping malocclusion as defined in Appendix D.
Mr. Marks, there is a suggestion in your brief that there might have been other alternatives to deal with this situation. Is that in the record?
Yes, so let's talk, well, the reason that's there is that there are various forms of orthodontic treatment. All we're talking about here is comprehensive orthodontic treatment, which is a years-long process involving the installation of appliances.
I know what that is. What are the alternatives?
Well, there's something called interceptive orthodontic treatment. That's at 130 CMR 420.431, I want to say B or A. So interceptive orthodontic treatment is something less than comprehensive, and it's for the purpose of avoiding the development of a handicapping malocclusion. So
Was there any evidence on that in this case?
No, there was no evidence on
So
that.
there wasn't evidence that was put in of something less than comprehensive orthodontic treatment?
That's right.
That could have been provided?
That's right. Because the request for prior authorization was for authorization for comprehensive orthodontic treatment.
Right, but in that, in that, Dr. Riscala says, and there's nothing less than this that will do the job. So it would have been logical if there was something less than this to put that into evidence.
It was his burden. He simply asserted that in the flow chart he created that mimicked the language of the medical necessity requirement in 45204.
But I don't know that it's a simple assertion. He's the expert, right? And he's an expert, and he says, look, I think she needs this, and I don't think there's anything less than this that's going to get the job done. I don't know that, what does he have to do, go through all the alternatives? I'm not sure he does. He's an expert.
He has to explain it. And this is where the hearing officer was coming from in that language I just read. The HLD index form and the medical necessity narrative expressly requires the provider to explain why. I'll read it. The medical necessity narrative must clearly demonstrate why comprehensive orthodontic treatment is medically necessary for the patient. Nothing that Dr. Riscala put in the forms he provided explained anything that's included in the medical necessity narrative in
This is
Appendix
the
D.
footnote in your brief, right, where you went through this.
Yes, and it's the holding of the hearing officer. The hearing officer was left with no evidence, no testimony that there was a handicapping malocclusion. That is an absolute requirement to obtain funding for comprehensive orthodontic treatment.
What exactly did the Commonwealth's expert say in terms of the need for this treatment?
Essentially, the Commonwealth's expert agreed that, it wasn't the Commonwealth, it was Mass Health's expert, agreed that there appeared to be occlusal trauma that was causing chipping of the teeth. But ultimately, also, by the way, and I can get back to this, the expert scored the patient's bite using the HLD index, and I will get into that further. But ultimately, the expert said that comprehensive orthodontic treatment for this condition was not medically necessary. And again, what is important, what is crucial, is that there be a demonstration that there is a handicapping malocclusion, and there was no such thing here. And that's the problem, ultimately. Interestingly, the expert, and I'll give you the record site, the expert did testify that he scored the patient with 10 points for something called anterior crowding. And you will see this on the HLD index form. If I can find it, I will tell you what page it exists. I don't have it right now. Oh, here we go. The HLD index form and the medical necessity narrative is at volume 1 of the record appendix, page 29 through 33. On the HLD scoring, there are 10 points provided for anterior crowding on each arch. So 5 points for each arch. The expert scored it at 10 points. Dr. Riscala only scored it at 5 points. So what does this tell us? This tells us that under the scoring, the anterior crowding fell short. It didn't amount to the threshold that would establish that it was a handicapping malocclusion. That's okay, right? Because Dr. Riscala had the medical necessity narrative to explain why, even though this crowding fell short of the threshold, why, nonetheless, there was a handicapping malocclusion. But he didn't do it. And that's part of the problem here, and nor did the Mass Health expert. Ultimately, there was no explanation as to why this patient's condition amounted to a handicapping malocclusion to warrant comprehensive orthodontic treatment. So,
would you agree that the regs that we're looking at are pretty hard to follow?
I will walk you through it,
Well,
if it'll help you.
you know,
That's a different question.
I got to tell you,
To
yeah.
help you, I'm here.
Not only is it a different question, when you walk me through it, we will walk in a circle. Okay, at least I've walked through it a few times and I keep walking in a circle.
Let me give you the
Because you're citing Appendix D or whatever it is, and there is a regulation that says,
There were several.
flat out says,
Yeah,
arguably at least, you're not supposed to look at that.
well, let's not go there. That's not precisely what it says.
Not precisely what it says, that's
Right.
why I said arguably.
That's right. There are at least 3 provisions.
Without regard to service limitations described in 130 CMR 4.420.
That's right. So that raises the question, what is a limitation? Okay? So let me walk you through this. First of all, this notion that that language, without regard to the limitations in all those other sections, means ignore the handicapping malocclusion requirement. That notion is not expressed in the regulations anywhere. It simply says, without regard to the limitations.
Without regard to service limitations.
Service limitations.
And then the part
And-
that you rely on comes under this odd heading, service limitations and requirements.
And requirements.
And requirements.
That's right. And so the answer is that the medical necessity requirement, that includes a handicapping malocclusion, is a requirement, not a limitation. How do we know that? Well, 130 CMR 450.204, which is the general medical necessity requirement, says in subsection D, additional requirements about the medical necessity of mass health services
Interesting.
are contained in other mass health regulations and medical necessity and coverage guidelines. That's exactly what the handicapping malocclusion requirement is. It's an additional requirement about medical necessity.
What's the difference between a limitation and a requirement then?
Good question. I anticipated that too.
I hate being,
Here
so
is,
obvious.
here is an example.
Well, no, I love having the help.
130, here's an example. 130 CMR 420.410B3. I'll say it again. 130 CMR 420.410B gives us an example of what is a limitation. So 410, let me just find it. This is a section, 420.410 is called prior authorization, and it describes the circumstances under which a provider must obtain prior authorization before it can render the service. Comprehensive orthodontic is one of those things. 410B says services requiring prior authorization. 410B3 says any exception to a limitation on a service otherwise covered for that member, as described in 130 CMR 420.421 through 420.456. That's all those sections that we are disregarding the limitations in. For example, isn't this helpful? The regulation gives us an example of a limitation. For example, Mass Health limits prophylaxis to 2 per member per calendar year, but pays for additional prophylaxis for a member within a calendar year if medically necessary. This is the EPSDT requirement, right? You cannot have artificial limits that apply to EPSDT eligible members, that is, members under age 21, if the service is otherwise medically necessary. So that's why there's all this language in at least 3 separate regs that says disregard the limitations for EPSDT. But this reg gives you an example of a limitation, a limit on the number of services in a certain period of time per member, unless there's a medical necessity to disregard that limitation. That's not handicapping malocclusion. Handicapping malocclusion is a requirement of medical necessity. And so the entirety of the plaintiff's argument turns on this subheading in 420.431 that says service limitations and requirements. But medical necessity and handicapping malocclusion is a requirement. It is not a limitation. And that is the entirety of the case right there. Mass Health did not issue a regulation that says it can disregard the requirement of a handicapping malocclusion to require a child to go through 3 or more years of orthodontic treatment with braces, et cetera, to require Mass Health to pay for it without requiring that there be a demonstration of a handicapping malocclusion. Not just any old malocclusion, because orthodontics can always be used for cosmetic purposes to fix a bad bite, which is a malocclusion. It needs to be a handicapping malocclusion to ensure that the service is for a medically necessary condition. And ultimately here, there was no evidence that what was happening with this patient rose to that level.
Well, because they didn't use the words handicapping malocclusion?
In part.
Well,
And
what's
also
the rest
because
of it? Because, I just took a quick look. I mean, and it reminded myself. I mean, the expert representing Mass Health says, I think this is something that they should do.
he certainly
this
felt
is
that it
something
could be
that
fixed.
it's needed.
That's right. That's right. But ultimately,
Then stop short of saying that he would predict that there would be a problem in the future when cross-examined by Rascala on the question.
he also ultimately stopped short of saying there was a medical necessity for the treatment. And the problem is that it's not enough to simply assert that the patient has it or needs treatment. Appendix D is very clear that the description of the problem, the description of the severity of the malocclusion must be articulated, detailed, explanatory, such that the agency can decide that this kind of service is warranted under these circumstances.
Okay.
We've run over time, but I
Thank you, Your
found
Honor.
it
I would
helpful
have to
on
do
both
it
sides.
upfront.
Thank you both.
Thank you.
That concludes our argument session. We are in recess.
All rise.